Hello everyone and welcome to MediaNama. On July 10th, the Delhi High Court refused to order the Central Information Commission or CIC to open its hearings to the public. The court was responding to a petition filed by 5 journalists who said that the CIC's current system is too secretive and goes against the spirit of the Right to Information Act. So, the CIC is the top body that hears appeals and complaints under the RTI Act. It has the power to order government departments to share information and to penalize officials who break the rules. But even though these hearings are meant to protect citizens' right to know, the public and the press are often not allowed to attend. The petitioners had asked the court to allow both physical and virtual access to these hearings. While the court didn't give a direct order, it did ask the CIC to explain its position and file a new report in 6 weeks. One of those petitioners is with us today, journalist and RTI activist Saurav Das, to talk about why this case matters, what's at stake, and what he hopes will change. Saurav, thanks for being here. What made you personally interested in how the CIC conducts its hearings?
Thank you, Aakriti, for having me. So I've always used the RTI Act to, cull out information from government bodies. I've been filing RTIs since 2018 and have unfortunately seen its downfall in the years thereafter. The Central Information Commission is the apex body for central government institutions that accept RTI applications, right? So if a central body rejects your RTI or you have a grievance with its reply, you can follow a two-level appellate mechanism to reach the Central Information Commission, where after a waiting period of anywhere about 1.5 to 3 years, your case is listed and heard by an information commissioner. So many of my cases, in privacy related matters, on matters relating to COVID, and general lawmaking have all reached the Central Information Commission, and have been heard by, several information commissioners over the years. But what I did see was, it used to be a very secretive meeting. It still is, where only the officers from the public authority, the complainant or the appellant on the other side, and the information commissioner are present in the room along with their staff. So what happens generally then is, I have had a personal experience with this, is that the information commissioner nowadays, because of the kind of appointments that are taking place, are blatantly partisan. So they sort of argue on behalf of the public authority to deny information. So I felt that, if there could be some amount of public transparency when it comes to the conduct of these information commissioners, it can act as a deterrent for them. And in one of the hearings, unfortunately, it was very acrimonious because the Chief Information Commissioner, Hiralal Samaria, was hearing a matter concerning a ministry, central ministry, and was vehemently, opposing any kind of disclosure on behalf of the public authority. Now, the Information Commissioner is supposed to act as a totally unbiased and almost like a judge, right? Not taking sides. But then, such is the case now that information commissioners do take sides, and always on the side of the public authority to deny information. So he was doing the same thing, and I, objected to it, and in as many words did call him out in front of everybody. So it almost turned into a shouting match between the two of us. So yeah, and I did put it out on Twitter, and thanks to my lawyer, Sai Vinod, it was actually his idea to get certain journalists, get a coalition of journalists petitioning the court to perhaps increase transparency by way of public access and virtual access during these hearings, which could deter such actions from the commissioner's side. So that was the idea.
Yeah, that sounds pretty insightful. So I just wanted to know, what does transparency mean to you in the context of public accountability and democratic governance?
I think democracy can't go on without transparency, because opacity is where democracy dies. Really, in that sense, because, if you do not know how your laws are being made, what is the thought process behind making those laws, if there's no accountability, it's monsoons and we see all our road infrastructure, our bridges crumbling down during monsoons. And this happens every year. Every year in North India, there's a thick smog, and you never know what these authorities are doing about it. So, and that is precisely because there's very less transparency about their actions and any kind of public scrutiny. So democracy really dies because, these decisions are then taken in closed door meetings, sometimes on a completely unscientific, in an unscientific manner. And the brunt of it is borne by the public, especially the marginalized. And if there is no public scrutiny about the actions, then there is, then the government will do as it wants to. So, and when it wants to do whatever it wants to, then, things can go out of hand very quickly. In the past 10 years or so, we have seen how the government has shied away from any kind of transparency, has diluted the RTI Act itself. And, you see all of that now coming out, the skeletons, coming out of the closet through, symptoms like these, like the air pollution and the infrastructure collapse and the economy going haywire. So, yeah, so ultimately that all of that, percolates down to the masses and on the health of a nation.
Yeah, that's pretty helpful, I believe. So now let's talk about your representation to the CIC in July 2024. So what exactly were you asking them to do and what happened next?
Right. So, a group of people, including me, and some very eminent activists who have worked on RTI and transparency and public accountability for many decades now, we put together a representation before the CIC, asking them to, allow exactly what we asked the High Court to do, which is to allow unhindered access to the Central Information Commission hearings, both physically and virtually. But then we did not hear back from them. And we were contemplating this action for a long time. And, it took its own sweet time to actually, fructify. And then my lawyer, Sai Vinod, actually thought that it would be a good idea if journalists, a group of journalists could assert their right to report on such proceedings, just like how journalists are free to, walk inside a courtroom, sit there and report from there. For us to like assert those rights even with the Central Information Commission, because the commission is really even though it is a statutory body, the courts have recognized that the information commissions do a quasi judicial function, right? So they adjudicate on cases. So there's no reason why they should not be following what our courts are now following, which is, unhindered public access, the system of open courts that we follow.
Yeah, could you walk me through how you prepared and submitted that representation?
Yeah. So, firstly, we wanted a group of journalists. I was ideally aiming for 10 of us to petition the court. So we have a freelancers group where I put out a message saying, in the West, we do see a lot of these people coming together from the same field and asserting their rights in a systemic manner, including journalists, right? So, but we seldom see any such movements in India, any such efforts in India. So I, pitched this idea on that group saying that, we should, all of us should really get together and petition the High Court to allow public access to Information Commission hearings. And about 10 to 15, I think 15 to 20 people reached out to me, expressing their willingness to join in this cause. So I was actually, I asked and I discussed this with my lawyer also about having 15, 20 people on board. But he told me that, collecting the wakalatnama and the signatures would become a big hassle. So might as well reduce it to, a fewer number of petitioners. So, but we still decided on 10 people. 5 of them could not follow up. So we were left with 5 of us, and the other 4 journalists are pretty distinguished, have won big awards, and, have used the RTI also in the past. So it made the perfect sense to, go ahead with them. And we all sort of put together our resources, and the lawyer had his vakalatnama ready and the petition ready. We had look at it, we suggested a few comments, we got the vakalatnama from, some people were in Bombay, some people were elsewhere, so everybody sort of got it notarized, put in the effort, and posted it to our lawyer's place. And finally we went ahead and filed the plea in the High Court. Yeah.
Okay. So, how did you feel when you submitted it? Were you hopeful or like skeptical?
So a lot of my reporting revolves around the court and the law. So I've seen sort of the inside working of the courts. So I was not very hopeful because
Okay.
I've come to realize that, much of these public interest causes and litigation is a matter of sheer luck. The justice system today is a lottery, especially in the higher courts, and that's sadly the case. So I was not really hopeful. I mean, of course, there was a glimmer of hope because we saw that it was before the Chief Justice's bench, and the Chief Justice is a pretty reasoned man himself, and holds a good reputation amongst other lawyers and the legal fraternity. So I was hopeful about that, but I always had it in the back of my mind that perhaps, it can go either way. But the court did give us a patient 20-minute hearing, almost 20-minute hearing, and disposed of the matter with whatever it felt was right on the first day itself, which was good. Which was good. I mean, because even though the order turned out to be something which we did not, were not expecting, which is basically number one, it asked us to go to the CIC and make a representation, and directed the CIC to take a decision on the representation expeditiously. And number two, for us to also go to the Supreme Court and implead ourselves in a pending case there, which is on virtual access to these hearings. So, I mean, both are fine, but then the court did not delay the matter for a long time, which is, very uncharacteristic of the Delhi High Court, because Delhi High Court has this huge problem with listing of cases where, the matters are there are 100 matters that get listed, but the judge is only able to hear 60 or 70 of them, and the remaining 30 cases, get adjourned to after 4 months or 5 months or 6 months. So that would have been a sheer waste of time. So I was thankful that the High Court at least, made up its mind on the very first day, uh, inconsequential of what its order was. Yeah.
Yeah. So, when there was no follow-up from the CIC, what made you decide to take the matter to the court?
I mean, that was the only logical route left, because if the institution does not listen to you, or does not even care or bother to reply to your representation, there's simply no other way other than, going to the court. I mean, of course, there's another way, which is for all of us to go and sit outside the CAC and CIC and, uh, protest, right? Like a sit-in protest or a hunger strike or something.
Yeah.
But I don't think anybody has the means of the time or the interest to do it for a matter like this. So we tried our best to engage with the institution, but unfortunately, and very characteristic of how things are for the past 10 years, the institution did not bother to respond. So this was the only way left.
So, how do you perceive the role of formal petitions and legal processes in bringing about reforms like these?
So I do see the importance of petitions like these, and they are means to uh, reach those noble ends. But I also see the importance that on ground level, grassroots level movements, the kind of impact they have is much, much greater, because that actually reaches into a person's consciousness. People actively engage with such movements, and that has a greater influence on their thinking and their ideas about a system. So, but again, I also recognize that it is extremely difficult, especially in a country where there are rising authoritarian tendencies of the government, for people to actually get together and create groups and protest or do some kind of a movement. I do see the challenges that come in an authoritarian regime. So it goes both ways. The courts are also responsible to induce social changes, systemic changes by way of its own jurisdiction. But equally important are also, or perhaps maybe more important, are also grassroots level movements that many of these co-signatories in that representation that we sent last year have been doing for decades now. Aruna Roy, Nikhil Dey, the MKSS, the NCPRI have been doing for so long.
Yeah. So before we move into the resistance you faced, um, you never heard back from anyone at the CIC informally, right? Even off the record.
No, nothing.
Okay. So what kind of resistance or obstacles did you face, either from the CIC or other institutions?
In terms of this petition or in general?
Yeah, in general and in terms of this petition as well.
The CIC has almost become defunct, because I have not heard anything from them for the past many years now. I think the last bold decision that it gave was in 2018. Since then, by way of appointing its own loyal men, the government has ensured that it becomes another department under its wing, right? The job of the Central Information Commission is to hear those cases and adjudicate whether or not transparency is required in that particular subject, or that particular case. It has to decide one way or the other. But increasingly, and this has now become a systemic thing there, it's that the information commissioners are extremely reluctant to order ministries or public authorities to divulge information, unless they come from maybe Department of Posts, or a culture ministry or something like that. But otherwise, especially in the high profile ministries like foreign ministry, home ministry, institutions like Supreme Court, they are extremely reluctant to give any kind of order for divulging information. So that has completely stopped in the past 7 years now. Yeah, 6 to 7 years. So would call it a defunct institution. People, there are people who go with public interest matters, but there are also people who go for their personal grievances, like with their passports, with their ration cards, etc. I don't know how they are functioning in those kind of cases. I hope they have some empathy and that human nature where you actually see through the pains of the people and would do what you're supposed to do. But in public interest matters where you would want to hold the government to account, the Central Information Commission has completely capitulated to the government's pressures, even if there's any pressure at all. There are officers within the Ministry of Law and Justice, because that closely relates to my work, who have told me that for the past 4 years, they haven't gotten an order of disclosure from the Central Information Commission, and they were laughing about it. I mean, I laughed along with them, but my laugh was, because I was sad. But that is the case with the Central Information Commission. In some cases where the petitioner puts on a lot of pressure and, like me, becomes almost like a shouting match, you see the information commissioner actually passing some sort of an order, but in a strict sense does not abide by the duty that he is supposed to do, which is to adjudicate the case then and there. What it does is then redirects or sends back the RTI to the public authority to take a decision, which is absolutely illegal because it is the CIC which is supposed to decide on disclosures, not the offending party before it, right? So, yeah, these are some of the challenges that have now becomes endemic to the Central Information Commission.
Also, like, were these more procedural hurdles, or was there pushback against the idea of openness itself?
I think increasingly so, they have a set of, High Court judgments or Supreme Court judgments which do not really favor RTI Act. So they use portions of those judgments in their orders to justify not giving an order for disclosure. So that has become a pattern. You pick up any order from their website, which is publicly available, and you would see those same, quotations from those judgments being used over and over again to deny people their right to know.
Yeah.
So the people being appointed are itself, anti-disclosure, anti-RTI, anti-transparency.
So what's been the most discouraging moment in the entire process?
Um, uh, I mean, I have stopped having hope from that institution, so I'm not really disappointed anymore. Yeah, I just find it, as per their game plan, it's systemic, But problem is, I can't even fault the courts entirely, but the manner in which the courts deal with RTI matters. If by any chance, and this has happened before 2014 also, before 2018 also, where the CIC passes an order for disclosure and the public authority rushes to the High Court to get a stay on the order. The stay is given on the ask, right? So the courts are very quick to stay those disclosure orders, which is actually really sad because the court should have applied its mind, and then it never takes up that case for many, many years after that. So the cause is also lost, right, and precious time is also lost. And number two is the manner in which the court does not take up RTI matters with urgency, because the essence of the RTI Act is time and urgency. But when it goes to the High Court, they do not show the same urgency. Again, I can't entirely fault them because the judicial system is also crumbling. There is very high vacancy of judges in many of the high courts, some functioning with only 60% of its sanctioned strength, some with 70%. There are frequent transfers of judges, frequent changes of the roster bench, because once the bench changes, the new bench is supposed to hear the matter all over again. Judges do not have time because there are 5 million pending cases. They have more serious matters to attend to: bail matters, liberty matters, criminal matters. There are civil suits which are pending for decades together before them. And therefore, the judge does not really have the time to sit down and apply their mind and come to a conclusion that would set the law right, So these are some of the very practical problems that our high courts also face. So I wouldn't entirely fault them. But where I would completely fault them is to not do anything to address these problems, because one problem leads to another problem and then it becomes a cycle, right? If I fault them for not taking up RTI matters, they would say, oh, look at the number of cases. If you fault them for that, then they say there's not enough judges, and then go on and on. So what I would entirely fault them, and of course the government is a huge player here because it's the government not appointing judges anymore. They are not they are the ones not sitting on the files, not clearing appointments, opposing appointments despite the law being settled. I would fault them entirely for that, which is leading to, cascading effect throughout the system.
Yeah. Yeah. So let's talk about solutions now. What practical steps can the CIC take to open up its hearings without compromising genuine confidentiality?
So I think if they could have, and that is our demand as well, if they could have some non-arbitrary, non-whimsical written procedures in place, which they would publicize on their website, I think that would be a good step forward. And of course, there could be some matters, matrimonial matters that may come up before the CIC. So it could have, I mean, it already has certain procedures in place. If it could develop those more and have some set guidelines in place, to protect privacy of those couples, or maybe a sexual assault victim or something, then that would go a long way.
Okay. So do you think upgrading the virtual setup, like using WebEx instead of NIC studios, would be one way forward?
Yeah, absolutely. I mean, there are several ways in which they could, upgrade their infrastructure and ensure that, it truly upholds the level of transparency that it should follow. So, like you said, WebEx could be a good platform, maybe a Zoom platform, or maybe even live telecast on YouTube. There are all mediums and means available today. Is just the matter of will, right? Do they have the will to do it, which is clearly missing. So we are still contemplating on our next steps, but we'll definitely, pursue this matter either in the High Court again, or maybe in the Supreme Court, or at an institutional level with the CIC, but we will pursue it.
So, and if those changes were made, what would that actually mean for the general public, RTI users, or journalists like us?
So it would mean, of course, that anybody can walk in, or anybody could access those hearings and sort of observe what is going on in those cases. It also increases public transparency, because public scrutiny, because maybe like researchers or maybe journalists who want to analyze the CIC's functioning could access and observe and create their own conclusions and create a report out of it. That, and also a person who has a case before them, maybe their relatives want to also join in, so they could join in easily through any through like virtually or physically also. So there are many benefits. I mean, but the idea is to have an open system where what happens out of it is left for the public to decide, right? Not for the institution to decide whether or not to allow that to happen.
So, have you received any feedback from other journalists, activists, or RTI users about this petition?
Yeah, they were very appreciative of it, and they really like the fact that a group of journalists actually petitioned the court, because that shows that there is, some sort of unity and shared concerns about our institutions, not just to other journalists or activists, but also to the courts, to the government, and to the general public.
So, yeah, that was very helpful, Saurav. Thank you so much for walking us through this. We'll be keeping a close eye on how the CIC responds. And to everyone watching, for more such videos on tech policy, follow MediaNama.